Hello, everybody. Hello, Catherine Gaston. Thank you for coming in and saying hello. Aww. We're almost at 5K. We're almost there. Hello, Nana Laura. Hello, Eileen Carlin. Hello, Sobe Liz. Good job. Oh, that's such a cool thing. And you get first dibs on all the jeans. Hello, Linda Applegate, you sweet, sweet woman. Hello, Spider-Man. Hello, Charlie. Good to have you here, sweetie. And she says that back. She says that too. Don't you, Ava? Don't you, Ava? Come on. I went out in the yard and I picked catnip. So that is all fresh, homegrown catnip. You know, Billy strength. Mm-hmm. That was my excitement for the day. For the whole day, I picked catnip. That's what I did. That and worked. Worked on cases. Isn't that right, Ava? Hello, Tiana Miller. Hi, Evie. Hello, Finn7. Good to see you, sweetheart. Well, you know, there's a reason for that. You're not of the feline variety, as far as I know. Hello, Patrick B. For cats that don't respond to catnip, typically they do respond to silvervine, which it grows like a little berry. That dries out, and they can either chew on the silvervine sticks, or eat the berries, or you can grind it into a powder. It comes in all forms. Humanip. Well, they do say take a little nip, out of the fifth. Yeah. Excuse you. That face. She makes the funniest faces. Hi, Tiny Kitten Esquire. All right, guys. So tonight, we're going to check out Lake Forest Park and see a man who is insistent that the police are lying. And we are going to go to, I think it's Michigan. And we've got a judge systematically breaking down an argument piece by piece. You might need a spreadsheet. And then we've got just a very quick little update.
Mr. Cruz, Saulo Cruz. I see you're here, 5A031-7470. Good afternoon, Mr. Cruz. How are you?
I'm good. Good afternoon. How are you?
Good, thanks. So you are here. Sorry, you're free to go, Ms. Chala.
Okay, thank you.
Yep. Okay, Mr. Cruz. So you're here on a ticket that was issued 3/18 of 2025 for failure to renew your registration. Are you contesting or mitigating at this time?
Contesting.
Okay. In that case, I'm going to swear you in. Will you raise your right hand? Swear to tell the truth and nothing but the truth?
Yes, I do swear.
Great. So what do you want to tell me about this incident?
I was not driving the car. I was in Dallas with my daughter's birthday is on March 18th. This car belongs to my brother. I have my name on the title because I helped him because of his credit. As far as I know, the car was not being driven because it was some defect. So if he was driving at the time, I don't talk with him since New Year's, so I don't know. But I have proof that I was in Dallas with my granddaughter.
This officer saying that he checked your identification.
And he's lying because I was in Dallas. I have all the proof that was me, and he can try to look at his camera, but he didn't check my driver's license. It's impossible.
What proof do you have that you were in Dallas?
I have my plane ticket. I have pictures of me with my granddaughter on March 18th on the 4th Zoo. I have my wife, my daughter.
So when did you go to Dallas?
On the 17th.
Of March?
Yeah.
So this happened on March 2nd. On March 2nd, he pulled you over.
I know. The infraction says violation date is March 18th. And I never drove this car, even if it was March 2nd.
The officer wrote the infraction later. So let me read you what his narrative says. On March 2nd, 2025, I was conducting uniform patrol in the city of Lake Forest Park, driving a fully marked police vehicle when I observed a Ford Focus displaying expired tabs of 1 of 2024. I initiated the traffic stop where the driver was positively identified by his Washington State driver's license to be Saulo Cruz, date of birth 9/4/1972. Cruz stated that he had already been pulled over and given a week to correct his expired registration. I confirmed that his Focus had an expired registration. In addition, Cruz was pulled over by a Kirkland officer on 2/22/25 and provided with a warning. At this time, I provided Cruz with a warning and gave him the opportunity to get his registration up to date by March 15th. I told him I would run his license plate on March 15th, checking for the new registration date in the system. I confirmed the address on his license was current and that he received mail there. Cruz was then released. On March 18th, I ran Cruz's Focus through my MDC, his computer, which still displayed the registration expired of 1/24/24. So this citation was mailed to Cruz's address on file.
Yeah, and he's lying because I never drove this car, never. He needs to show that my face because he never saw me.
Well, I mean, the problem I have is the only proof I have here is a sworn statement by the officer saying he checked the license.
And you have a sworn statement for me, and I can prove I never drove this car. I never drove this car.
How can you prove that?
The same way that he can prove that he saw me.
Well, I mean, it's more than just his word over yours. Have you registered this vehicle?
It's registered in both names. My brother is Cruz also. It's Bruno Cruz. He's the one that drives it. I don't have access to the car.
Do you own the car?
I'm on the lease due to his record. He makes the payment. I don't make the payment. The car is not near me.
Well, if you own the car, it's your responsibility to make sure that it's on the road registered.
If the car, for me, and my understanding that the car was not being driven.
Well, how much does your brother look like you? And if you're willing to help your brother out by putting a vehicle in your name because of his credit, are you willing to, maybe give him one of your old licenses, or, lost your license and got a replacement from the DMV and then your brother found it and used it? I mean, how far will you go for your brother?
Okay. Well, now you're on notice that this car is being driven.
Now I am
this,
not.
this car needs to be registered.
Now I am not. But when the time of the infraction, I was not driving the car. I was not aware that the car was being driven.
Okay, but again, that was 2 months ago, and I'm not hearing you say that you registered it. So I'm going to dismiss this ticket today, but I'm telling you,
and I thought, and I thank you, and I already work with my brother for him to fix this because it's his car, but I don't drive that car.
Okay, well, again, as long as you're an owner, it needs to be registered if it's on the road, and you're on notice now that you need to get this car registered. And whether you registered or your brother registers it, this car has to be registered, okay?
Okay.
Okay, so I will dismiss this infraction today, and you won't get any paperwork. You're all done for the day.
Okay, I appreciate it. Thank you.
You're welcome.
Don't really seem like you appreciate it so much. You still kind of seem like you're salty about it and ungrateful.
Next case is the State of Michigan versus Philip Keck. That's file 25-43388-SM.
Thank you, Your Honor. Jonathan Baber on behalf of Mr. Keck.
Hi, Your Honor. I'm here as well.
All right, I do see Mr. Keck is with us as well. Ms. Brucker is here. Mr. Baber, I've received two things from you. One is a motion to compel discovery and or dismiss for lack of probable cause. The other is a motion to withdraw. Which one would you like to do first, and how do you want to proceed today?
Let's do the motion to compel with motion to dismiss first if possible, Judge. I do have one witness to call on that.
All right. Ms. Brucker, have you filed a response to that motion?
I did.
I thought I read it, and I don't see it in my court file at the moment. Let me make sure I didn't misplace it someplace. I cannot find it at the moment, Ms. Brucker. Do you have it right there with you that you could email it to the courtroom and have, can we print it out here or not?
Yes. Yeah.
Could you email it to me, Ms. Brucker?
Yes.
I know I've seen it. I'm positive I've seen it, but I just don't have it with me.
Yes, just give me a minute and I'll email that to him. Judge, and I did just want to say, as far as potential witnesses, the only witness I could think of would possibly be Deputy Dean. He explained to me yesterday that he and one other deputy are the only ones on today in the county, and that if he was called out on something, he would not be able to be here. And I don't see him here right now, so I don't know how this is going to go, if the court's going to be prepared to rule without testimony or not, but I just wanted to indicate that.
I appreciate that. Thank you very much. Mr. Baber, who is it that you want to be calling as a witness?
Andrea Cerveni. She works with the Michigan Department of Health and Human Services. She's been subpoenaed. As I applied a copy of the subpoena to the prosecutor in this court. She is available via Zoom. Her testimony is going to be rather brief. It's impeachment only testimony.
That is the statement in her report that you referred to about what the original deputy said.
That's correct.
Ms. Brucker, did you have a copy of that report that she submitted, Ms. Cerveni?
I did. Mr. Baber submitted a number of exhibits. I did see her report.
All right. Mr. Baber, is she going to testify consistent with what is in her report?
And Judge, that report is not drafted by Ms. Cerveni. That report just reflects Ms. Cerveni's statements. She was the one who took the phone call from Deputy Dean on that particular day. She made notes of her conversation, and those notes ended up making it into that report. So that's just a brief bit of testimony that I need from her. I think I have a total of 16 questions to get us there.
Is there anything that you need that's not in your arguments already? I'm just trying to save a little bit of time. I'm not saying that I'm basically saying I'm not going to dispute what you're telling me she's going to say.
Basically, she's going to say what was drafted in my motion, Judge.
All right. Ms. Bruker, do you have any objection to me taking what's in his documentation as an offer of proof?
No, Judge.
All right, Mr. Baber, if I do that, do we need to have Ms. Cerveny testify today?
No, Judge. With that, I would ask this court to excuse Ms. Cerveny from her subpoena and allow her to log off.
All right, ma'am, you are free to go. Thank you very much for being here. Appreciate your time.
Thank you.
All right, Mr. Baber, thank you very much for assisting me with that. Give me just a minute to make sure I remember what was in Ms. Bruker's brief, and then I believe I would be ready to hear your arguments.
Thank you, Judge.
All right, it is what I thought I remembered. Mr. Baber, go ahead with your argument.
Thank you, Your Honor. I'm going to take it chunk by chunk and try to be as brief as possible, beginning with the equal protection argument in regard to this case. Now, I don't make this argument lightly, but if you look at it from the perspective of Philip Keck, it raises questions about whether or not he's being treated differently than other individuals in a similar situation. If you look at Mr. Keck, he filed a claim stating that he was a victim of domestic violence, and the prosecution says, we're not going to prosecute. He did it again in this instant case where he was the victim of domestic violence and had to use self-defense. And again, the prosecution declined to treat him as a victim. Followed up a third time where his wife, Alyssa, fraudulently used his name and signed checks from a business account she's not associated with, and signing the checks to herself personally. He is a victim there. And again, the prosecution denies him access to justice. Instead, they favor Alyssa Keck. And it makes us question, what is the primary difference between Mr. Keck and Mrs. Keck? And the only difference that is on paper is that Mrs. Keck is a female and Mr. Keck is a male. So there's a slight bias here because the prosecution hasn't provided us with any other reason for declining to treat Mr. Keck as a victim other than stating they have broad discretion about what charges they wish to bring. Now, that may be so, but there's a limit to that power and a limit to that discretion, and a prosecutor cannot be making charging decisions based upon gender and preferring one gender over another and protecting females over males, which appears to be the case here. Mr. Keck is just looking either for an explanation or equal access to justice.
That is a bold allegation, my friend.
In this situation, the prosecuting office should have, especially on the forged check case, recused itself and sought an outside prosecution through the Attorney General's office, as they routinely do when there's a conflict. And in this case, they decided not to do that, probably because it could be evidence used against the victim in this case for forging checks, because it's a crime of dishonesty. So ultimately, they are limiting my client even in raising his own defense by refusing to even submit this out for another prosecution to take a look at it. I'll move on to the probable cause in this case, Judge. Again, this is a situation where it is a he said, she said situation. Both have injuries consistent with their testimony. Why they decided to charge Mr. Keck and not Mrs. Keck is beyond me. There's no evidence leaning one way or the other to support that Mr. Keck was the actual aggressor in the situation. And if you look at what Deputy Dean had stated to the Department of Health and Human Services, even he said, hey, the timeline's confusing. I personally do not know who the aggressor was in this particular case. So Deputy Dean himself, by his own admission to Michigan Department of Health and Human Services, didn't have probable cause to arrest or charge Mr. Keck in this case. And without that probable cause, the case should be dismissed. Moving on to the motion to compel side of this, Judge, I'm not asking for all police reports concerning Alyssa, Mrs. Keck. I'm just asking for the police reports and the body camera concerning Mrs. Keck and Philip Keck. This is a long history between the two of them having verbal disagreements over how their children should be raised and who should be in their children's lives. And ultimately, the police contact has been numerous between the two of them concerning that particular issue. That issue was at case in this particular situation, and therefore it's relevant to the history in this case. And may eventually become an issue at trial. I'm not saying that the stuff I'm requesting is going to be absolutely admissible at trial, but this is just the discovery phase. We should be entitled to it, and then we can make arguments later in motions in limine whether or not it's going to be admissible. Further, excuse me, Judge, there is one particular police report where a third-party witness in this case underwent a psychological evaluation, and it was determined that this witness could not tell the difference between a truth and a lie. That's very relevant when this witness may be called for a jury to hear, hey, this is what this person said, but this person also, clinically speaking, does not know the difference between the truth and the lie. So all of the things that we are requesting, I believe, are relevant to this case at this point in time. And we'd be requesting that those be turned over to us unredacted, along with the video containing statements of all the witnesses in this case, Judge. Thank you.
All right. Ms. Bruker, any response?
I'll be quick, Judge. As to the equal protection argument, essentially, Mr. Baber is alleging because there are warrants that may have been denied that his client has been discriminated upon because he's a male. Mr. Baber used to be a prosecutor. I know Your Honor used to be a prosecutor. We deny warrants for many reasons. And he's not made, he's not made the argument, the link between Mr. Keck being a male and these warrants being denied. As to the affidavit, the information required in an affidavit of probable cause is some evidence on each and every element of the crime so that the magistrate or judge reviewing it can determine that there is probable cause that the crime was committed. And that is there in the face of the affidavit. Questions about who said what, about whether or not who the aggressor was, are going to be questions of fact for the jury or the fact finder. As to the reports, I still don't think Mr. Baber is given a causal connection for why reports from 2022 would be relevant in this particular case, and body cam footage from all of these reports. When you look at these, some of these are civil disputes where police came out, didn't take any action. Some of them are other kinds of complaints. I'm not sure if any of these came through to our office to be reviewed, except maybe one of them. And I don't know whether or not, I'm not sure what the retention policy is on body cam, whether that's available. So I would ask for the court to deny that as well.
All right. Thank you both very much. Just for the record, I wanted to state that I did review all of the documentation that was submitted by Mr. Baber on the CD, including his motion to dismiss and all of the exhibits that went with it. So I've thoroughly reviewed all of that information prior to today's hearing. So let me start with the previous complaints, because I think that helps me explain why I'm going to do what I'm going to do in the other two equal protection and probable cause decisions. As to Mr. Baber on page 5 and 6 and part of page 7 goes through each of the documents that he submitted and that I reviewed. So let me comment on each of those. It's going to take me just a minute to do so, but I think it's will help with the understanding of where I'm going with this. So on page 5, the first bullet point says that there was an August 28, 2022, Michigan State Police responded to a quote false complaint where she alleged that the defendant pushed her. I reviewed that document. It's Exhibit F, and I do not find that to be a false complaint. There was physical contact noted in the complaint. The defendant's arm, and the finding was that it did not rise to the level of domestic violence, but it did not indicate that there was a false allegation. Therefore, I don't believe that that document is relevant, as it doesn't show a false complaint or a false allegation. The next document, August 28th, Alyssa requested assistance for a civil standby so she could retrieve belongings. Again, it's not a false allegation. There's no evidence of bias or prejudice by the police or anyone else in that document. So I don't make any finding as to that as well. The third one is on September 18th, 2023, the police, Michigan State Police responded to a domestic where the defendant was the victim of domestic violence. That is an allegation that Mr. Keck has made. It is not what was found within the document. Within the document, it's found that the kids could have confirmed whether he was the victim or whether she was the victim. And Mr. Keck did not want the police to interview the children, so that the report then was unsubstantiated and no action was taken. So it's not, again, not a false allegation, no evidence of bias, but this was a decision that Mr. Keck made to not have the children interviewed, who could have very easily confirmed which of the two parties was at fault. The next document is September 29th of 2023. The police, Michigan State Police, assisted the Sheriff's Department in a welfare check of the children. Again, not a false allegation, not an indication of domestic violence, and no use as an equal protection argument, no use as a discovery argument, no use as a probable cause argument. On October the 1st of 2023, the next document was a defendant requested assistance in locating Alyssa and the children. Again, this is not an allegation of domestic violence. It's not an allegation of false complaints. And it was during the divorce process, and it appears that the defendant is using the police to assist him in his custody and parenting time arrangements or arguments. The next document is from October 6th of 2023, where the Sheboygan County Sheriff's Office notified the Otsego County Sheriff's Office that they had located and arrested Alyssa. And then they transported her to the Otsego County Jail, where she was lodged. Again, there's no issue of domestic violence here. There's no issue of a false complaint or false allegations. There's no evidence of any police bias or prejudice. It's simply a statement of fact. And so I don't believe it has any relevance to an equal protection argument, probable cause, or discovery. The next document is from November 22nd of 2023. The defendant contacted the Otsego County Sheriff's Department to report a parental kidnapping. This, in essence, is a custody dispute. It's Alyssa is alleged within that document to have returned to the house later the day, and there's no false allegations on her part. This is again the defendant reporting this as a parental kidnapping, attempting to use the police in his custody and parenting time dispute with Alyssa, but it does not appear to be any false allegations on behalf of the police or any false allegations from Alyssa, and it appears that the defendant is using the criminal justice system, not the alleged victim in this complaint. The next document is on December 28th of 2023. Defendant contacted the state police to do a wellness check on Alyssa. And the police found Alyssa and subsequently found a pistol on her front lawn. Again, there's no documentation or evidence that Alyssa made any false statements. There's no evidence of any bias by the police or by the prosecution, and there's no impeachment evidence available in that document that I was aware of or that I saw. And so I don't believe that it is relevant either. January 19th of 2024 is the next document. The Michigan State Police responded to a dispute between the defendant and Alyssa. The police arrived to find Alyssa locked defendant out of the house and would not let him in. Again, the parties are now divorced, I believe, at this point. There's no allegations of any false statements by Alyssa, any allegations of domestic violence, and there's no indication of any impeachment evidence available from this document. Again, so it does not go to an equal protection argument, does not go to probable cause, does not go to any discovery that I'm aware of.
So up in the top right-hand corner, there's this Juliana Solis, and she's trying to follow along, and her facial expressions kind of say everything.
The next document is on February the 5th of 2025. The Otsego County Sheriff's Department investigated Alyssa for fraudulently signing his name to checks drawn on the defendant's business account. This is an allegation talking about he said, she said. This is exactly what the defense has railed against, saying it's he said, she said. This is that. He's making a claim that she falsely wrote her name on a check and his business account. When interviewed, she told the Sheriff's Department that she had the ability and had in the past done that. They told her that this was a civil matter, and that's where it was left, and that's where it went. Given my experience as a prosecutor and as a defense attorney for the last 38 years, that's a normal occurrence. Probably 50 or 100 times every year as a prosecutor and a defense attorney, you see something like that. This again appears to be the defendant trying to use the criminal justice system to aid in his divorce, custody, or parenting time process, as opposed to anything otherwise. I'll come back to that in just a minute, but that's where I'm going to leave that for the moment. The next document is on February 7th of 2025. The Michigan State Police responded to a welfare check of the children filed by the defendant. Once again, the defendant is using the criminal justice system to assist him in his custody parenting time dispute. There's no evidence of false allegations. There's no evidence of bias or prejudice. And so that was irrelevant information. The next one is from the same date, February the 7th of 2025, where Alyssa contacted the Otsego County Sheriff's Department alleging the defendant came into the home and took all his firearms. Again, this is not a false report. She indicated that the firearms were missing, found out later that the defendant had previously moved them by someone else. He didn't tell her that the firearms were removed from the home that she was in. She reported that the firearms were missing. There's no false allegations, no allegations of bias or prejudice by the police. And again, I see no impeachment value or bias or prejudice or equal protection argument from that. The next document is from February the 8th of 2025. The Sheriff's Department served Charlevoix County PPO on the defendant and asked the defendant about his firearms. This is similar to the above, the February 7th finding that I just made. Again, there's no indications of falseness, bias, or prejudice, no indications that could be used to impeach anybody, and it's therefore irrelevant information. The next document is from February the 19th of 2025. The Michigan State Police conducted a forensic interview of the child, KSK, and where they indicated that young child struggled with telling the difference between a truth and a lie. Whether or not that continues to be the same thing, competency and knowledge of the ability to tell a truth or a lie is a day-to-day, sometimes thing that happens especially for a child over time. So there may be a change from when it happened then to where it is now. However, there's no information in the probable cause affidavit that the information in the probable cause affidavit came from KSK. The only indication is that child was present, but there's no evidence of what the child said or saw within the probable cause affidavit. So whether or not KSK can or can't tell the difference between a truth and a lie, it makes no difference in whether or not there's sufficient probable cause within the document. Within the probable cause document. The next document put forward is February 26th of 2025, where the defendant contacted the Michigan State Police to report Alyssa for check forgery. This is after he'd already had that same investigation request denied when it went, I believe, to the Sheriff's Department. And so once again, he is attempting to continue to use the criminal justice system to force his way and his view of how things should be done when it's already been denied once in the past. And it was, so I find no bias or prejudice there when the state police took no action, when the Sheriff's Department had previously investigated it and took no action. The last document that it's alleged is on February the 27th of 2025. The Sheriff's Department were called for a civil standby for the defendant's mother retrieved his personal items from the home. And Alyssa refused, apparently, or alleged to refuse to hand over a trailer hitch and refused to answer why she needed the hitch and refused to turn over a pair of cowboy boots. There's no indication that any of that is false. There's no indication that that is domestic violence, and there's really no impeachment evidence there. It's not surprising to this court that divorced parties don't get along. But that doesn't mean that there's any impeachment or bias or prejudice information that's there or that would be appropriate for a criminal trial. At best, it's impeachment and it's information that the defendant already has through the witness of his mother. All right, as to the equal protection argument, I find no equal protection facts in this case. The defense can certainly say, well, I'm a guy, she's a girl. The prosecution hasn't accepted my side of the story. We are far from being able to call that proven. The story fits just as equally to say the assessment of credibility is that they don't believe the defendant and they believe her. That's just as rational an argument as the argument that says, well, it's he said, she said, and because they're siding with her, it must be because I'm a male. That's a conclusion without a factual basis on these facts as I find them today. As to the probable cause determination, I find within the affidavit of probable cause a statement from Alyssa when she called 911 stating that she was assaulted by, and she indicated who it was, Philip Stephen Keck. That does support the charge offense. Further in that probable cause affidavit is Alyssa stating that Philip, the defendant in this case, began screaming in her face. She was afraid that Philip was going to hit her. She recalls Philip picking her up off the couch and throwing her on the rug. Alyssa did show a fairly large rug burn on the left forearm. All of that supports probable cause. The defense argues, well, lots of other things were left out, as in all of the things that I just detailed on the record. None of which, the things that were left out, none of which, in my mind, rise to the level of taking away probable cause. In addition, the defense never argues about the physical evidence that's noted in the affidavit, which is the fairly large rug burn on the left forearm of Alyssa. In essence, they left it out, which is what they're arguing that the prosecution did. They left out certain information. Well, the defense did the exact same thing. It left out any argument, any statement of fact about the victim, Alyssa, had physical evidence on her that corroborated the story that she told to the police. Secondly, so I don't find a proper factual basis within the arguments in this case for a lack of probable cause. Next, as to a legal basis for this, where there is the defense is entitled to, constitutionally, they're entitled to challenge the veracity of the warrant affidavit. That's under the case of Franks versus Delaware, 438 U.S. 154 from 1978, and which is upheld in Michigan under the Supreme Court case of People versus Franklin, 500 Mich. 92 from 2017. The defendant is only entitled to an evidentiary hearing, however, on that, where the defendant makes a substantial preliminary showing of a deliberate falsehood or reckless disregard for the truth by the affiant. There is a presumption of validity with respect to the affidavit supporting the search warrant, and the attack must be more than conclusory and be supported by more than a mere desire to cross-examine. There must be allegations of deliberate falsehood or of reckless disregard for the truth. None of the allegations in this case rise to that level. The allegations of negligence or of mistake are insufficient. It's only when those requirements, that of deliberate falsehoods or reckless disregard, if met, that is when there would be a requirement of a hearing, and then there would have to be a preponderance of the evidence, a probable cause determination that those allegations are true. I don't find in this case that there's even proof requiring a hearing. I don't find any allegations of deliberate falsehood or reckless disregard, because all of the allegations of falsehoods, in my view of the evidence, ring untrue. There's no falsehoods involved. There are he said, she said statements, but there's no indication of that the police knew that any of those things were false at any time. Even having said all of that, even if you would believe that some of those statements were false, if you put the remedy for that is you put all of those statements together, you put all that information into the affidavit of probable cause, and then you determine, is there still left probable cause? And that's the remedy that's listed in Franks versus Delaware and in the Michigan Supreme Court case of People versus Franklin. And quite frankly, after I did that, I'm still left with the allegations of Alyssa, which were corroborated by the physical evidence at the scene of the bruise or the large rug burn on her left forearm, which is consistent with how she said the evidence occurred. A probable cause is a very low standard of proof. It's less than a preponderance of the evidence. It is more than a reasonable suspicion, but it is a probability, not just it's not a reasonable belief. It's not anything greater than that. It doesn't, in fact, you can be wrong more often than not and still have probable cause. So for all of those reasons, I'm going to deny all of the arguments. I don't believe that there's any relevant or improper discovery that would be, proper discovery that would be obtained. I don't believe that there's any equal protection violation. I don't believe that there's any probable cause violation. And so the motions, all three motions are denied. Mr. Baber, you still have your motion to withdraw. Do you still wish to do that today?
Yes, Judge.
I have read all of that. I'm not going to require you to put all of that on the record unless you want to. Is there anything else that you want to say?
Yes, Judge, just not in regard to the motion, but how it came about. Ultimately, I tried to resolve these issues without having to file motions in every one of my cases that I still have outstanding, which are 10. Unfortunately, I could not make that happen. They are still making me go through the motions of getting an order for this court before they will reassign these cases to attorneys that they have the room to take these cases up, as was indicated in an exhibit attached to my motion. So I apologize for taking up the court's time, but I was left with no other choice.
I don't have any problem at all with the way that you've done this, and I appreciate you, the upfrontness that you've given to me in providing me with this information. Ms. Brucker, do you have any objection to his motion to withdraw?
No, Judge.
All right, I will grant that motion. Mr. Baber, I don't remember seeing a proposed order. Did you submit one to me?
I have not, Judge. It's kind of my first case. It's my test case. I want to see this court's temperature on it. So I will draft an order granting the motion to withdraw. I'll also supply the court with that in order denying the motions in the previous motion for this court.
Do you want to, well, I'm just trying to think whether or not we should, for any other case that you have, do you want to do something under a 7-day notice for that? I mean, I'm inclined to grant your motion on just about every case, well, every case that you're on, unless there's some reason for immediate action is necessary for an attorney. But I don't know that would be, I mean, we can appoint a new attorney fairly quickly. So
what I think I could do, Judge, is we could leave it on and I'll have a conversation with Ms. Brucker. Maybe we can just agree on some language and she'll stipulate that she doesn't object to my motions, and we could supply an order to this court, and you know, the court's freely able to keep them on the docket or sign the orders based upon what's in the motions.
I'm satisfied by that. I'll leave it to your judgment how you want to proceed on that, sir. So go ahead and send me a proposed order on this particular case, and then on the future cases as well. And I'll just go with what I see once you get here. Now that we have denied these motions, where do we need to go next?
Judge, I guess I'd suggest, since Mr. Keck's going to be getting a new attorney, maybe we just get a status conference so he can get up to speed with his new attorney, and then we'll go from there.
I think that's a great idea. Mr. Keck, do you intend to hire your own attorney, or do you still want to have court-appointed counsel?
Still would appreciate court-appointed.
All right. Mr. Baber, if you would.
Once I get the order back from the court, I can notify MDIC of the situation, and they are supposed to assign new counsel immediately. So
if maybe you would include just a line in that proposed order that requires them to appoint new counsel, I'd appreciate it.
Okay, can do, Judge.
Thank you very much. And we will set this for, I'll set it 3 weeks out. I'll send notices out to, once we get the new counsel, I'll send notices out to that. Mr. Keck, if you would keep in contact, once you're advised of who the new attorney is, make sure you get a hold of that attorney, and so that you don't miss anything. We will send notices out to you. I have you on Old 27 North in Gaylord. Is that correct, Mr. Keck?
Yes, Your Honor.
All right, we'll send the notices there. If there's a mix-up of some kind, contact the court a few days in advance of the next court date. Make sure you've got an attorney. Make sure that we're ready to go. All right.
You said 3 weeks out. You're just going to notify me of the date, not?
Correct. They'll send you a notice setting a hearing in approximately 3 weeks. That should give you time to meet with your new attorney. Hopefully, we'll get the paperwork back and forth from Mr. Baber to the new attorney quickly. But I just want to make sure that you're not, the things aren't going too slowly. I want to make sure that your rights are protected that way. All right, sir?
All right. I appreciate that. Thank you.
All right. That's all for today then. Thank you.
Thank you, Judge.
State of Kansas versus Hunter Powell, 25 CR 8. County attorney appears by Jill Gillette. Are you Hunter Powell?
Yes, sir.
Mr. Powell, you were present through part of the rights, but you weren't present at the very beginning. So I'm going to go through what your rights are. Your
Okay.
case is a little different because there's felonies involved.
All right.
And so you have the right to a trial to the court or to a jury as you're charged with a felony, you additionally have another evidentiary hearing you have a right to. That's called a preliminary examination, also referred to as a preliminary hearing. You don't need to make any statements right now. You have the right to be represented by counsel. If you wish to be represented by counsel but cannot afford counsel, you can apply to the court. If you meet the financial criteria, I'd appoint an attorney to represent you. Additionally, at a trial, you have the right to be presumed not guilty. The state would have a burden of proof showing that you're guilty beyond a reasonable doubt before you can be found guilty. Additionally, you would have the right to cross-examine the state's witnesses and call witnesses on your own behalf if and utilize the court's subpoena power to be sure that witnesses attend. Additionally, you would have the right to testify or not testify as you see fit. If you chose not to testify, that cannot be considered against you in determining if you're guilty or not guilty. Do you understand these rights?
Yes, Your Honor.
All right, I'm going to go over the charges against you at this time. And count number 1, you are charged with aggravated assault. Counsel, I need to hold on for a moment. I need to locate the sentencing guide now. I'm not in my standard office and I don't see a sentencing guideline book here, so I may ask the state in regards to the penalties. But in count 1, you're charged with an aggravated assault. That's a severity level 7 person felony. The severity level 7 person felony is punished up to a $100,000 fine. And Ms. Gillette, what would the grid show in regards to the minimum and the maximum?
11 to 34 months.
Okay, 11 to 34 months. A lot of that deals with what a person's criminal history is. So there's a lot of different, and that is a prison sentence. That is not a jail sentence. So the count number 2, you're charged with making a criminal threat. That's a severity level 9 person felony. Again, there can be a fine up to $100,000. Ms. Gillette, what would the penalty range be for the 9?
5 to 17 months, Your Honor.
5 to 17 months. Again, that would be a prison sentence. Count number 3, you are charged with aggravated assault. Again, that is a severity level 7 person felony. That would be punishable from 11 to 34 months with Secretary of Corrections and fine not to exceed $100,000. Count 4 is another aggravated assault. Again, a severity level 7 person felony, punishable from 11 to 34 months in Secretary of Correction and a fine not to exceed $100,000. Count number 5 is aggravated child endangerment. That is a severity level 9 person felony. That is punishable from 5 to 17 months with the Secretary of Corrections and also a fine not to exceed $100,000. Count number 6 is also an aggravated child endangerment with the same penalty range that I just stated. Additionally, there are allegations in regards to a firearm being used in these. That can, if you were a person convicted of these offenses and it involved a firearm, there could be sentencing ramifications such as a presumption of incarceration, even if the person's criminal history would be without otherwise might be probation. These are very, very serious offenses, obviously.
Yeah.
And I strongly recommend that people be represented by counsel. Are you planning to hire an attorney?
I would like to, but my mom's talking to my uncle at the moment because right now these are false allegations. I'm not a violent person and I never did this. It was
Okay, you don't, please, hold on. Now, this is not the time to be talking about the facts of the case.
Okay,
Yeah, and anything that you say could be used later on. So,
okay.
I hold on, just, I don't need to talk right now. You know, if you, under these circumstances, if somebody hires and you want the person that's hired as an attorney to represent you, that's fine. However, you may wish to consider applying for to the court. You're a legal adult. You're at age 28. Is that correct?
Yeah.
All right. So, you know, it would be your income. That would be the question mark, and your assets in regards to, so you may qualify for court-appointed counsel.
Okay.
You can fill out the paperwork. They have it over there at the jail, or they can get it. That would be returned to the clerk of the district court. I would review it. If you meet the financial criteria that the state sets down, I would appoint an attorney to represent you. That does not necessarily mean that they would be free. Those costs could be assessed to you if at a later date you are convicted. Any questions about that?
No.
Are you going to apply for an attorney then?
Yes.
All right. What I'm going to do is I'm going to set what we call a preliminary hearing control date. And I'd ask the clerk to look for a date 10 days, at least 10 days out, so that he can apply for an attorney and can also, you know, hopefully have an opportunity to consult with that attorney before that time. At that hearing, Mr. Powell, your attorney would advise if you wish to have or waive a preliminary hearing. That and those are things that you should really consult with your attorney about.
Okay.
All right. So when the clerk has a date, if you advise me, I'll set that down.
Judge, are you wanting 30 minutes or an hour?
30 minutes would be more than enough.
Okay, we could do Wednesday, May 21st at, oh wait, that may be jury trial week. I'm sorry, hang on.
Now, sooner as opposed to later, as he's in custody.
We could do Monday, the 19th at 9 a.m.
May 19th at 9.
Yes, sir. Next Monday at 9.
Okay.
That's the pre-trials for Judge Webster. So either I have to do this before I start those, or I have to do this later in the morning.
What time do you start with Webster?
9. Ms. Judge Lee, if he had had a jury trial, would have been on that same list, but all of ours hadn't gone away.
And I haven't been notified that the jury trial in Butler County is going to go, because that may be the circumstance where I'll be here next Monday as well. So what time on the 19th?
We have a couple first appearances set for the 21st. Do we want to set this as the same?
That's fine.
Those
May 21st at
1:30.
1:30. Okay, so May 21st at 1:30 will be our next hearing. That's next Wednesday. If Mr. Powell applies for an attorney and he's qualified, then I would appoint an attorney to represent you, sir. And but we'll do that hearing at that time. Do you has a bond? I don't believe a bond's been set. Has there on this matter? Yes. Rested on probable cause. So I will hear the parties in regards to bond. Ms. Gillette?
Judge, I would ask for 15,000 cash professional surety. That's lower than normally I would ask on these kind of charges. No contact with the victims, and I would ask for GPS for that low of the bond.
All right, Mr. Powell, is there any statement you'd like to make in regards to the bond?
Yes, I would like to ask for A little bit of a liquidation. I've got $100 in my pocket and I have a physical service animal at home. I live right here at the Howard Housing Authority. I could make my court dates. I wouldn't miss them. I've been more than cooperation with your officers and I have nobody to take care of my animal for that time. Is there any way that we could do $100 surety or an OR on the understanding that I come back to court? I promise I would be there and I wouldn't do nothing stupid, Your Honor, I promise.
All right, well, due to the nature of the charges, I'm not going to go that low with the bond. I'm going to set bond, as you are a local individual, at 7,500 cash or surety. So there would have to be a cash or surety bond. You are to have no contact with the victim, going past the residence or place of business. You would additionally, you would be ordered not to possess a firearm or have one at your residence. And then if you have one already, then it would need to be turned over so that the officers know that you don't have one there at the home.
Okay.
I will not require a GPS, but again, at 7,500 cash or surety. But our next hearing date, as we indicated, is May 21st at 1:30.
So does that mean I need 750?
That's between you and the bondsman. That a lot of times they do charge at 10%, but that's a private agreement between you and the bondsman if you're going through a surety.
Okay.
So anything further on this case today? Very well, hearing nothing further, this matter is adjourned. The defendant can be returned to his cell. With that, we're adjourned.
90. Ma'am, are you Loretta Henley? And while Miss Henley's getting unmuted, sir, are you Johnny Henley? You're also muted, so I'm hitting the button for each of you to hit unmute, please.
Oh, yes. And this is our update. You guys may remember her, maybe not. It's been a long time, but he was MIA. She had been trying to serve him. They've been trying to get divorced. She couldn't find him, couldn't serve him because he was just gone. Looks like she found him.
So that we can have a conversation.
Yes, sir. Yes, sir.
Okay, welcome.
I don't know what's going on, but I can't hear anything.
Okay, let's see if we can get that fixed. We can hear you, Mr. Henley. That's a good start, but it doesn't appear you can hear us. So I'm
No,
not sure
that's
what
not
you,
it.
Can you turn up your volume if you go to your device or your system and try to?
Where are the settings? Because I can't hear nothing.
So we'll give Mr. Henley a moment to get.
What's going on? Speakers. Let's try that. Say something.
Does that work, Mr. Henley? Can you hear us?
Oh, yeah.
Okay, are you Johnny Lee Henley Jr.?
Yeah, that's me.
Okay, welcome. So I have here in front of me a judgment of divorce. I know we met last month and you guys both agreed to have that judgment prepared. It looks like it's been signed by each of you. Is that accurate, Ms. Henley?
Yes, sir.
Is that accurate, Mr. Henley?
Yeah.
Then I just need to take some testimony from each of you, and then hopefully we can get the judgment entered today. If each of you could please raise your right hands. Do each of you sound? Other right, please, Mr. Henley.
Oh, one more time.
Other hand, please.
Oh, then my thing must be reversed.
Oh, is it backwards? Okay.
Yeah, that's my left.
Sorry, it's backwards on my screen. It's all right. You can hold up your right hand.
Can I flip it? Can I?
It's okay. I'll take your. If you could raise your right hand, please, I'll take your word for it.
Oh, okay. All right.
You solemnly swear, affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth.
Yes.
Ms. Henley?
Yes, sir.
Okay, a lot of these questions are for you, Ms. Henley, just because you were the person who filed the complaint. When you filed the complaint for divorce, have you been residing? You can put your hand down, ma'am. Have you been residing in the state of Michigan for at least 180 days?
Yes, sir.
Have you been residing in Otsego County at least 10 days?
Yes, sir.
In your divorce complaint, you asserted that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed and there remained no reasonable likelihood the marriage could be preserved. Was that true when you filed the complaint?
Yes, sir.
Is it still true today?
Yes, sir.
You also stated in your complaint that you did not have any minor children with Mr. Henley and that you were not currently pregnant. Were each of those things true when you filed?
That we have custody of. Yes, sir. No, sir. We do not have any minor children.
Okay, you are not currently pregnant, are you?
No, sir. I'm not currently pregnant.
All right, and turning to the judgment itself, it indicates that neither party has awarded spousal support, and spousal support is forever barred. Ma'am, do you understand that that is a final order? It cannot be changed later. It is binding forever.
Yes, sir.
Do you understand that as well, Mr. Henley?
Yes.
Personal property is similar. It says that each party is awarded the personal property in your possession. That means you get what you have, but it also means you cannot come back to the court later and ask me to make an order with respect to personal property. Do you understand, ma'am?
Yes.
Yeah.
understand,
All
sir?
she would have to do is ask, but yeah.
Okay. And then the
I
orders
have
also state
numerous
that's to be divided. The parties don't own any vehicles and the parties don't own any real property. There's also no pensions, annuities, individual retirement accounts, or other retirement plans. Are all those things true, ma'am?
Yes, sir.
As far as that,
As far as you
Yes.
know? All right. Is there anything else that you think needs to be in the judgment for it to be final, Ms. Inland?
No, sir.
Mr. Hanley, how about from you?
no.
Then the court finds that the statutory grounds for the issuance of a judgment of divorce have been met. I accept the party's testimony here on the open court record. It appears that the judgment and its terms are fair to each of you, and each of you have signed the judgment, which means to me that you also believe they're fair to you as well. Because I found the statutory grounds to be met, I do also make the finding that there's been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage can be preserved. So I've signed the judgment on today's date. I'll hand it to the clerk's office for filing. Once it's filed in the clerk's office, the judgment of divorce will be final, and then they'll make a copy and mail it out to each of you. Any questions, Ms. Henley?
No, sir. Thank you so much.
Welcome. Any questions, Mr. Henley?
Not that I know of.
Okay.
So they were finally able to get divorced. I saw that third eye forehead tattoo, and I knew I had her on the stream before, and yeah, figured I would just give you guys all the update. I mean, that it's possible, except for I don't think the divorce would be allowed in Scientology. Definitely wouldn't be allowed to be done over Zoom. Yes, that's true. And he attempted to do that, but I think what he did was he did that, but looked at it on the computer screen, making it a mirror image. So what he was looking at was the correct L, but I don't know. I have no idea what he was doing, but it definitely was not his right hand. He raised his left hand. Your thumbs are on the inside. By, inside, so that was definitely his left hand. I do not know what that is, but it sounds very sci-fi. Hello, Stephanie. Oops. I'm hitting stuff, knocking stuff all over. No, maybe it's not for her. All right, guys, thank you so much for coming out. That went by quick. That hour just flew by. But I'm so grateful for all of you guys coming and hanging out with me tonight. We'll have to do this again sometime real soon. Be safe, be well, sleep sweet, and much love.